Today, the U.S. Court of Appeals for the Second Circuit heard arguments on a case that challenges the autonomy of Catholic schools in hiring and firing principals.
It was about the issue of the ministerial exception. Can the Catholic Church, in this case the Archdiocese of New York, pick its religious leaders, or can the state interfere with that process?
Former Principal Joanne Fratello filed suit against the St. Anthony's School in Rockland County, saying her firing in 2011 was due to gender discrimination at the hands of a new parish pastor.
Obviously, the Archdiocese firmly denies that happened, but we also say that that's beside the point because this kind of a case just shouldn't be in court in the first place.
In 2012, the U.S. Supreme Court decided the Hosanna-Tabor case, and that case concerned a fourth grade teacher, and the Supreme Court recognized that a fourth grade teacher who had significant religious responsibilities in training the students about her faith was a minister for purposes of federal law.
The attorney for the former principal says the ministerial exemption should not be extended to ministries that are not purely religious, and asserts the exemption could give any religious institution the right to discriminate on gender or racial grounds.
There's no reason why the court should ignore what the Supreme Court said just a few years ago, 9-0, and what the court has already ruled in 2008 to be the law here in the Second Circuit.
The case may take a few months to reach a decision. Lawyers for the Archdiocese are confident, but say a lot is at stake.
The government's allowed to get interfered with the selection of someone who leads prayer every day, who chooses the religious curriculum at a religious institution. If the government can decide those kind of religious leaders, then, all sorts of religious organizations are going to be at risk.
Reporting for Currents in Lower Manhattan, I'm Konrad Aderer.